Welcome, my name is Todd Villarubia. I'm the managing partner of Wealth Planning Law Group. I'm going to be speaking today about various techniques that are available to protect your wealth from creditors and predators. Our firm was founded 20 years ago on the very simple premise that we believe that our clients should be able to control and pass on to their heirs their wealth free of government and creditor interference. And today we're hosting this webinar in New Orleans, Louisiana, at our office. We have several advisors here that are with us that may be asking questions throughout, and this will all be part of the webinar today that we're recording. Again, I'm Todd Villarubia, and we hope that you're going to be able to get a good bit of value from today's meeting. So, what is asset protection? Well, what we found is that when you're younger, it's all about trying to grow your wealth. You're trying to save as much as you can. You're trying to grow your business. As you get older, the protection of your wealth becomes much, much more significant. That's why the financial planners, obviously, as you get older, will typically decrease the exposure to equities and will start getting into more bonds and safer investments that aren't as volatile. Well, similarly, in the estate planning world, it's one thing for us to actually do the wills and do those sorts of things, but then what happens while you're alive? How can we try to protect everything you've worked so hard for? And what we're going to do today is there's actually going to be two separate presentations. So this first one is going to be on various levels of asset protection planning, and then we're going to do a separate webinar for the second half of today that's going to actually talk specifically about these Delaware Asset Protection Trusts, which are really something that I think is beneficial to a lot of people. So basically what the asset protection process will do is that it kind of builds on the client's existing estate planning, and we're going to talk about the different methodologies that are available to clients, how they work, and the different levels of protection. We're going to provide some examples to y'all about some things that can be done, some of which are true across the country, some of which are only applicable in Louisiana. And we're going to discuss the importance of taking a team-based approach. At the Wealth Planning Law Group, we are really, we really feel that it's very important to have a team-based approach where the client and their financial advisor and their CPA and a qualified tax attorney are all meeting together so that we can all be on the same page to appropriately plan for the client. I've been in a lot of meetings where we'll uncover some need, and so for example, the 55-year-old client comes in, I ask them whether they have long-term care insurance, and if the answer is no, ideally the financial advisor is in that meeting so that the financial advisor can say, well, I can look into that. Or I might be talking about one particular, strategy, and the CPA is going to have some good insight into how it can be tweaked and even improved upon. So we're also going to be talking about the need to have a really good team-based approach. So how do we do this? Well, it's typically a 3-meeting strategy. First, we're going to kind of get to the initial meeting where we're going to gather all your financial information. We're going to ask some pretty tough questions a lot of times and start to develop a relationship with the client. It's really that foundational meeting is really important. We are not the right firm for every single client, and frankly, we don't take every client that comes through our doors. We're selective with the clients that we work with. And at that first meeting, we kind of get to know each other and see whether we're going to have a good cultural fit. And it's really important in that meeting, I think, to develop some rapport and see whether or not the client's motivated, because we can talk all day about particular solutions, but if a client's not motivated to act, we're not really going to get anywhere. So it's really important to kind of get to those issues of, what's keeping that client up at night, and, what's bothering them, what are their main goals, what are their main concerns. And what we find is if you ask the question why enough, and you kind of get to the root of the problem. So I'll have a client say, I'll ask them, well, your time's valuable, dear business owner. Why are you here today? And the answer might be any number of things. It might be, well, I'm worried about this ridiculous estate tax that's going to destroy my company, or I'm worried about my child that has, these disabilities, or I've got this other child that has substance abuse problems, or all of these things that we wind up, seeing when we're working with high net worth individuals. And we then have to kind of dig deeper and kind of keep asking why, so why are you worried about this estate tax? Well, I'm worried about losing my business. Why are you worried about losing my business? Because I really care about my employees, and it's been the golden goose that's provided me so much opportunity to live a fulfilling life, and I want that business to be able to actually, survive my death, and many of you may be familiar with the fact that 65% of second generation businesses fail. And by the time you get down to the third generation, it's more like 95% fail. And why is that? Well, sometimes it's taxes, sometimes it's creditors that are out there that are sued and, basically broken up a company. Sometimes it's just, oftentimes, it's that there hasn't been a succession plan put in place, which is something that we do to help clients kind of help ensure the validity of their business and that it endures and survives their lifetime. So that initial meeting in a lot of ways isn't really talking so much about the solutions. It's really kind of trying to pinpoint what the problems are and to kind of get an idea of what the assets are, what's going on with the client. We got to watch because in the asset protection arena in particular, you need to be careful. This is at true, good asset protection planning is really done on the front end before you get into trouble. Once you're in trouble and you're upside down, you're getting ready to file bankruptcy. Obviously, there's laws out there that are going to really limit how much freedom you have to do things. But if you can get on the front end of this and plan proactively, then there's a lot of stuff, as we're getting ready to talk about, that you could do to try to protect your wealth. Once we have that initial meeting, we've gathered a lot of the data. I find that it's helpful to then have that team meeting where we get the financial advisor and the CPA and we talk about, here's this strategy, here's this idea, what about this concept? And we kind of round table and brainstorm the concept and then try to actually come up with a definitive plan that we then put forth to the client. And that's really what happens in the third meeting is to then try to match the client's concerns and objectives and goals with the solutions that we have come up with as a planning team. And what then happens is you have everybody on the same page. The last thing you want to have happen, I think, is to have the client tell you their problems and we come up with a solution, but the CPA is not on board because now we're going to have some problems. And some CPAs are familiar with some of these concepts, some aren't. Some financial advisors familiar, some aren't. So by getting everybody to collaborate on the process, I think the client's best interests are always served that way. What is asset protection and what is it not? It's not about hiding or concealing assets. There are things that can be done legally where assets can be transferred, but you never want to be in a place where you're intentionally trying to defraud a creditor. Every state in the country has a fraudulent conveyance type statute, and they vary state by state. In Louisiana, it's called a revocatory action. And so each state, you have to kind of look to the state's laws. But if you have somebody that's currently being chased by some creditor, lawsuit, whatever, then you have to really watch that. One of the things that we will do is see whether there's actually a final judgment or not. And we have the clients actually sign off on a solvency affidavit, just basically saying that I'm solvent, here's my assets, here's my known creditors, here's the threats that these people could become creditors and what the financial implications are of that, so that we're real clear that we're not doing anything to defraud creditors. I can give a really good example. We have a client that came to us probably 3 or 4 years ago, back when the estate tax exemption was only $3.5 million back in 2009. And he owned probably 20 or 30 different businesses that collectively he was probably worth $40 million. One of his real estate transactions, unfortunately, he got upside down in. And there's a dispute in another state, actually, between him and the bank, but the bank's basically chasing him and trying to hold him personally liable for the entirety of the debt, which is pretty common. as many of you probably are aware, when you go into a business deal and a real estate transaction, usually the bank's going to try to get as much collateral as they can, not just the land that you're doing. They're going to ask for other stuff. They're usually going to ask all of your partners to sign a personal guarantee, and they're usually going to do it using Louisiana terminology in solido, which means that they can hold any one of the partners 100% liable for 100% of the debt, even though you might only be a 10% owner of the company. So this particular guy had, like I said, it was probably $40 million so net worth. And his concern, why he came to me, wasn't about asset protection. It was about the fact that he's worried at that point, with a 40 to 55% estate tax, possibility, that, his family, once he and his wife passed, could be looking at somewhere in the neighborhood of a 12 to $20 million estate tax as he currently stood. So we started doing all this estate planning, where we're removing business interests and setting up these family limited partnership structures and grantor trusts and all of this kind of complex estate planning stuff. Well, this potential creditor, this bank that's in another state, has been out there, and it's really not a substantial part of his net worth. If he did have to pay the whole amount, he would still be fine. But, they're trying to argue, wait a second, you transferred these assets to try to defraud us. Well, I think the law is going to be pretty clear there that we weren't doing it to try to defraud them, that the bank wasn't even a creditor, quite frankly, at the time. They don't have a judgment. They just have a debt on a piece of land there. And we were doing this fully for estate planning reasons. It really had nothing to do with trying to defraud the bank out of any money. But it's always something that we want to try to look at on the front end, so that we don't have any surprises. It's critical that the client, in that regard, gives us a lot of the information. Obviously anything a client tells us is protected by attorney-client privilege. But some clients sometimes are really kind of reluctant to tell their attorney the full scope of everything. So that's why we haven't signed the affidavit. That's why we make sure, is there any other assets? Are there any other debts out there that we need to be aware of? For a lot of clients, they're looking to try to maintain control. They want to discourage lawsuits, but again, try to do that proactively. And they want to do so, if possible, with as much certainty as possible, so that they know that this isn't just some sort of guessing game. So when to plan, like we talked about, we want to make sure that we are planning well before any kind of potential claim arises. We recently had a client come in that is worth about $20 million, has a couple of small business interests, and she was really concerned about asset protection. And, for a lot of people, you would say, well, why is somebody, worth $20 million worried about these things? Well, I'll tell you, there's a couple of things. First of all, globally, it has been estimated that 85% of all lawsuits that are filed in the entire planet, 85% of those are filed in the United States. And for Louisiana residents, as most of us know, unfortunately, Louisiana has one of the most litigious states in the entire country. So people are always concerned. I've got doctor clients, and in Louisiana, we actually have a limit of liability on medical malpractice, where the most that they have to pay is $500,000, although that's been challenged recently. Those doctors, I find, physicians in particular, are keenly aware and concerned about asset protection. And even when you have a medical malpractice cap, it's not that they're worried that if they cut off the wrong leg that they're going to get sued. They're worried that they have a big target on their back. So if they go get into a fender bender, that somebody's going to, sue them. And, people make mistakes. You go out to a Christmas party, you have some drinks, you get into a car wreck and somebody gets hurt, you could potentially lose everything that you have. So it's really important to think through these possibilities, and then to actually act upon it, to actually execute and say, let me try to, proactively now, well in advance of anything happening, try to protect my assets that I've worked all my life to try to build. There are still some options if you have existing debtor, creditors out there, but you always have to be mindful of these fraudulent conveyance statutes. As I mentioned, I talked about the solvency certificate or affidavit that we do, and we always ask the clients, if we're going to actually work with you on this, then I need to be able to have the ability to independently verify that, what you're telling me is actually accurate. So let's talk about, there's different levels of asset protection, and on very broad basis. There's certain exemptions and certain assets that are typically governed by state, but also by federal law, where certain assets are protected by law from seizure by creditors. Second level is that there, in community property states at least, there's this transmutation agreement that we can enter into. A third level is to actually go to professional entity formations. The fourth level is to actually use some leasing LLCs so that we can kind of segregate the different assets. The fifth level is to actually look at family limited partnerships where we're actually transferring assets, ideally to trusts for the benefit of children, grandchildren, descendants. Sixth level, which is something that our firm is really starting to get pretty heavily involved with now, are the so-called domestic asset protection trusts, which we're going to spend the second half hour of today kind of talking about, where even though you're a Louisiana resident, or you could be a resident of any state for that matter, you can set up a trust that is governed under another state's laws. And in particular, there's several states, there's about maybe 13 to 15 states now that have enacted statutes that really provide some really good asset protection. There's about 4 or 5 states that are really kind of considered to be leading edge. Delaware, Alaska, Nevada, Wyoming, South Dakota, those 5 states in particular seem to really be at the front edge, leading edge of this whole domestic asset protection concept that we're going to talk about in more detail. And then the 7th level is for really sophisticated clients, is to actually look at some offshore asset protection trusts. You need to be careful with those. A lot of people have read and seen recently that the IRS has been cracking down on these offshore accounts, but understand that there's a difference. In other words, as a U.S. citizen, you are taxable on your worldwide income. So if I have an account in New Orleans, or whether I have an account in Afghanistan, doesn't really matter. If that account is earning money, I need to pay taxes on it. And the thing that you have seen in the newspaper is clients who were unfortunately advised to go put their assets into these Swiss bank accounts, for example. There's also some stuff going on down in Central and South America and some of the British Virgin Islands and some places like that, where people were advised that if they put their assets there, that they wouldn't have to declare the income on those assets, and that's what the IRS has rightfully, quite frankly, been cracking down on. That's not what I'm talking about when I'm referring to these offshore asset protection trusts. There are certain countries that actually have treaties, or they're just their laws, where they will not respect a judgment of a foreign country. And for some clients that are really, risk adverse, the concept of placing the assets, you'd still pay taxes on any earnings on those assets, but by placing them offshore, if there's any kind of judgments against that client, arguably under that country's laws, they're not going to respect the judgment of a United States court to try to enforce and seize that money. Now, with each of these levels, what happens is it's a constant, almost like a seesaw, balancing act that we always have with our clients in many of the discussions. You want simple, or do you want effective? Pick one, because the simpler it is, the cheaper it is, but the less effective it is. The more complex, the more expensive, so you got to kind of pick where the client fits on that continuum, if you will. We have a lot of clients that will come to me and say, oh, I can't stand this estate tax, issue. I think it's ridiculous after I've paid income taxes and sales taxes and all these other taxes that when I die, the government's going to come in and take 40%. And we start talking about solutions. You want simple? Well, fine. You can do annual exclusion gifts, $14,000 a year, as many people as you want. But if you're worth $40 million, $14,000 a year is not helping you a whole lot. Now, we have more complex solutions, but, some clients don't like that complexity. Well, you got simple, you got complex, you got taxes. You can't have it all. and you got to kind of measure with the client as far as how much complexity they're willing to take on. And I always tell our clients that it's really kind of a process. You got to kind of, the old saying about you eat an elephant one bite at a time is really true. Let's start with getting your foundational planning done, and then we're going to build on that. So we might get your wills, living wills, powers of attorney done, and then we're going to start with maybe getting an insurance policy to pay, to help fund the estate tax. And then maybe we're going to talk about doing some annual gifting and some 529 accounts. And then if you're charitably inclined, we might start talking about doing some charitable planning. And if you got business interest, then we're going to build on that and maybe look at transferring some of the non-voting shares of the business interest. So it just has to build on one another, and it just takes some time to do all of that. So that's kind of the overview of the different levels. Now let's start talking specifically. So level 1 protection is the exemption. So in other words, under state and federal law, there are certain assets that are exempt. So, and I can speak to Louisiana law. Again, if you're listening to this broadcast in a different state, then you're going to need to consult with a good estate or tax attorney that can kind of advise you on what your state's individual limitations are. But under Louisiana law, I can speak to the fact that, for example, I believe it's $50,000 of your home equity is exempt from seizure by creditors, and that's governed by the state statute. A lot of people mistakenly believe that the entire value of their equity is protected under Louisiana law, and that is not the case. I think people saw or read about, for example, O.J. Simpson when he went through the civil trial. He moved down to Florida, bought apparently this very expensive mansion, and then they couldn't seize it. Well, that's because under Florida law, apparently, the personal residence is exempt from seizure. So they kind of moved those assets into a form so that under that state's laws they couldn't take them. But Louisiana, that doesn't apply. It's not a full-blown exemption. It's only like the first $50,000. In addition, it's interesting under the Louisiana statute, and I think I would venture to guess most attorneys, much less the public, has no idea about how the life insurance exemption works. It's really interesting. There's a statute that governs both life insurance and annuities. And if you read the technical definition of the statute, it's pretty clear that the cash value contained in a policy that is issued more than 6 months before a writ of seizure, that cash value is protected. Now note, why I said issued twice is that the cash value and insurance policy that is issued more than 6 months. It's not from the date that you put the cash into the policy. It's the date that the policy was issued. So arguably, we could have a client that's worried about getting sued. We get them with the financial advisor and say, go get a permanent policy. You can minimally fund it for now, right? If the suit happens, what's going to happen? Well, for any of you that have been involved in a lawsuit before, lawsuits take a long time. There's discovery, there's all these, things that happen before the trial ever occurs, right? So that they have depositions, there's interrogatories, there's all these things that happen, and then we finally get to the trial date, and then the other attorney needs to delay it. I've got a conflict, trial date gets pushed back, and then let's say that you bought the policy before all this stuff happened, you get all the way to the trial date, and you lose. Well, under Louisiana law, you then have an automatic right to appeal up to the appellate court, and it's going to take some time before the appellate court is going to hear your case. And then let's say you lose there again. You have the right to ask the Louisiana Supreme Court for a writ, which is basically a term that, will they take your case? Now, the Louisiana Supreme Court does not have to take your case, but you can certainly ask them to. And that's going to take them some time, again, to decide whether they're going to take the case. And arguably, under the specific language of the statute, you could wait until the day before the Louisiana Supreme Court denies your writs and go liquidate everything, put all the cash into that policy the day before they deny, and under the specific language of that statute, it should be protected. Now, there's not a whole lot of case law out there. I'd certainly hate to push it to that, and I don't want to be the test case for it. But I'll never forget when I was a younger attorney, I've been doing this for 20 years now, when I first read that statute, I said, maybe they made a mistake. Maybe the language really isn't that. Well, what's interesting is that the next paragraph in the state statute deals with annuities. And it's very clear that the language for the annuities is different than the language for the life insurance policies. With the annuities, it's based on the date you put the cash into the annuity. And it's crystal clear under the statute. So anybody, any kind of creditor that would try to argue that the intent of the statute for life insurance was from the date you put the money in, I think you've got a very clear example there in the same statute saying, well, if that was their intent, then they would have put that into subsection A for life insurance, just like they did into subsection B for the annuities. So the life insurance is really a great asset protection vehicle. We don't sell life insurance. We're not licensed, but we are big proponents. We think in a lot of situations, life insurance can be just a wonderful tool for everything from, helping to pay for the estate tax to the cash in those policies being asset protected, buy-sell agreements funding, even just from a pure investment standpoint. Typically, even on a long-term basis, you're going to get an after-tax equivalent 4 to 6% rate of return, which certainly beats the daylights out of existing money markets and savings accounts that are only earning 0.1%. Annuities, again, under state law are protected, but for the cash value, there's always limitations to all this. I'm just talking from a 10,000-foot view today. IRAs and retirement accounts under Louisiana law also protected from creditors and seizures. So there's things out there that a lot of the public don't know about, and frankly, even some financial advisors, such as cash balance plans. Cash balance plans aren't for every client, but they're a really good tool for if the situation fits. And we've got clients that have cash balance plans that are putting in $150,000 every year tax deferred, and it should be protected under state law since we generally protect these pensions and IRAs, 401ks, SEPs, etc. And then we already mentioned the homestead in Louisiana has a very limited exception. There's some other things that are protected, your tools, I believe one vehicle, so there's some other smaller things there, but those are some of the major ones. And then federal law, there's actually federal protections as well relative to these retirement accounts. And under the Pension Protection Act, even IRAs and bankruptcy can be protected in many situations. So the planning opportunity at the real, the base level one kind of protection is to have a client that if they're worried about these kind of things, okay, well, why don't you take some of the assets that are currently in a brokerage account or in a savings account, maybe even your real estate, right? If you have a bunch of real estate and you have a bunch of equity in the real estate, maybe you go take out a mortgage on it and you basically, withdraw that equity out of the real estate. You basically come up with cash and put it into one of these vehicles, whether it's a life policy or an annuity, so that you can try to protect it if you think that there's going to be some threats coming down the road. Level 2 protection is primarily involved with community property states, and Louisiana is one of the community property states in our country, where we can basically take community assets and convert them to separate assets. A lot of people aren't familiar with this concept, but in Louisiana, unless you have a prenuptial agreement, you are presumed to have community assets when you get married. And what a lot of people don't realize is that community debts are then the liability of both spouses. So if the creditor is able to prove that the debt was incurred to try to benefit the community, then arguably they can go against both spouses for that community debt. But there's some options there. We have a client that actually has a bunch of businesses that are very risky. He's doing really well with them, but there's a lot of bank debt out there. They're just inherently risky businesses that he's involved with. And yet he had a good bit of cash. He had some cars. He had the house that were all paid off. So he went and spoke to his wife, and he said, I'm concerned that, they could take everything we have. So they discussed and decided that they would do a post-nuptial separate property agreement, whereby they basically eliminated the community property regime that they had under Louisiana law. Both the husband and wife, they need to be represented by separate attorneys, It has to be approved by a court under Louisiana law, but then once that happened, they literally were no longer having community property. The businesses were put into his name, the debt was put into his name, the house that was free and clear, the cars, several of the bank accounts and investment accounts were put into the wife's name. And by doing that, then arguably and there was no creditors that had a judgment already against them. So by doing that, we were at least able to protect the house and the cars and the bank accounts and some of the investment accounts. That if the husband did get sued in one of these business activities, that his wife's separate assets at that point would then be protected. Any questions from any of our live attendees right now?
Yeah, I have a couple questions. Going back to the annuities, that could be either fixed or variable.
Correct.
Annuity. Now, but you said there is a limit on the amount of assets in annuities?
Well, what it is they look at the time period in which you put the money into the annuity.
Okay.
And I want to say it's maybe a 9-month or 1-year period.
Okay, now with life insurance, you said it was 6 months
from the date of issue.
For the issue.
Right.
Okay, 6 months prior to a lawsuit, or the filing of a suit.
A writ of seizure, in other words.
Well, writ of seizure, that's not the same as filing the lawsuit.
Exactly.
Okay.
That's why I use that example.
So
you could get a permanent policy with very little life insurance policy with very little cash value, get sued, you go to trial court, you lose, you have an automatic right in Louisiana to go to appellate court, you lose, you have an automatic right to ask the Louisiana Supreme Court for writs. While they're codulating on that, you then could arguably liquidate your assets, put it into that insurance policy, and if once they then deny the writs, let's say, now the creditor goes for a writ of seizure. Under the state statute, if you follow the exact, literal definition of the statute, that policy, even though you put the money in the day before the writ of seizure comes, because the policy itself was issued more than 6 months, by the time you get to the Supreme Court, it's a several-year process, right?
So, but with variable annuities, you think it's probably like closer to 9 months?
Yeah, but it's from the time the cash went in.
But not 9 months to right of
the writ of seizure.
The writ of seizure. So if, let's say, somebody filed a lawsuit against you, and the next day you went ahead and put all your money after a lawsuit was filed, you then the next day put everything into a variable annuity, as long as it's at least 9 months before that writ of seizure, which in all likelihood would be,
right?
Then you should be okay.
Well, at least let's put it this way: there's no case law specifically on it, but the issue is that your creditor would try to argue that it was a fraudulent conveyance under Louisiana's revocatory action. The debtors, of course, would argue, wait a second, here's a state statute that says what it says, which is money put in, 9 months before the writ of seizure is protected. So it's not like we can guarantee that result, but that's certainly what that statute says, and it's certainly better than if you just had money sitting in a bank account, let's say, and that is clearly subject to seizure. So
at least you have to fight for that.
Yeah, one of the things, it's a great question. One of the things that I try to tell people in all asset protection planning discussions is there is no 100% guarantee that that all of this is absolutely going to work 100% of the times. It's a matter of putting up enough roadblocks to try to frustrate the creditor, quite frankly. And the more roadblocks you put up, then the more likely it is that it's not going to be worth that creditor to come after you, and they're going to settle for pennies on the dollar. But once you get before court, you never know what the judge is going to say. That sometimes they'll try to find an equitable way to try to make things right, even when the statutes are pretty clear, and that happens, occasionally. So, in all of this, it's not like we ever say, oh, here's our 100% guarantee that it just doesn't work like that. But it gives you a significantly, I think, degree of peace of mind. I think of knowing that how you're way ahead of the game compared to if you hadn't done anything.
And then the next question is on the separate property agreements, like with your wife. I've always been told it was very, very important to do that before you got married.
It is.
Okay, but if you wanted to do one after you got married, that's still a possibility.
It is. Okay. It is. So, and most people don't realize that. So, we've always taken the position as a law firm that it's a good idea to at least talk about with a qualified attorney doing a prenuptial agreement before you get married. Why do we say that? Well, for a number of reasons. Number one is that in today's society, good or bad, it is what it is. We have about a 50% divorce rate, and then a lot of those people get remarried. And whenever we have a blended family, children, his kids from a prior marriage, her kids from a prior marriage, their kids together, the complexity factor goes up significantly. And the issue becomes that the assets can get real clouded. And what I mean by that is that there's arguments on both sides. In other words, let's say a person loses his wife, he gets remarried, he's got kids from a prior marriage, she's got kids from a prior marriage, and then he dies. The question is, okay, what are his assets? Well, she's going to argue in all likelihood that they're all community assets, because there's a state statute that presumes that all assets owned by a married couple are presumed to be community. His kids, on the other hand, are going to probably argue, no, these are all separate assets. He brought these assets into the marriage. And who's going to win that war?
Whoever has the least amount, whoever has the best attorneys, probably.
There you go. That's the answer I was looking for. That's the answer, is that you're going to wind up spending a tremendous amount of money on lawyers to try to resolve those kind of issues. If you do a prenup, separate property agreement, then you can avoid those sorts of issues. The second, so blended family is one of the reasons I think you do it. Secondly is, a lot of times spouses will say, well, that's not very romantic. Well, again, forget about, the romantic part. Let's think about just pure business here. The biggest cost in a lot of divorces is the division of the assets when the two spouses pass. So once again, the domestic bar makes a lot of hay and a lot of money off of when they're trying to, split up the assets, because there's legitimate things to fight about as to what's community, what's gotten commingled, what's separate, what's what. And there's going to be oftentimes there's two very legitimate stances that each side's taking. And by having a separate property agreement, you can avoid that. So the only additional hiccup, if you will, or hurdle that we have to jump is that once you get married, you're in a community. If you haven't done a prenup, you have a separate property agreement at that point. I'm sorry, that if you want to enter into a post-nuptial separate property agreement, the only additional hurdle after you're married is that you have to get it approved by the court. Whereas if you do it before you get married in Louisiana law, then each side, in each case, you have to have each spouse represented by separate counsel. The only difference is that after the marriage, you have to get it approved by the court. Whereas if you do it before the marriage, then you don't need to get court approval. It gets filed in the parish in which you live and in any other parish where you own real estate.
So if somebody is going to, once again, if somebody's being sued and they get slapped with a lawsuit, and the next day they say, okay, I need to do a separate property agreement with my wife so I can put everything in her name. Once again, is that going to protect you, or is that going to also be another hurdle, because they're going to say, well, you moved everything into her name and you did this. It's going to be
more of a hurdle. That's the issue. Again, there is no, and I'm a black and white math guy. I wish I could sit here and tell you that definitively 100% every time you're going to win. And in none of this stuff that we're talking about is that ever the case. But it is getting to a 70%, 80%, 90% likelihood that you're going to be okay.
Short of buying gold coins and burying them.
And burying them in there, right. So, okay. Level 3 protection is professional entity formation. So a lot of people don't think through actually setting up separate entities for their different assets. So we have some clients that are, let's say a lawyer, and his law practice ideally would be in one entity, and then he would have a separate entity arguably to hold his real estate, and arguably he could then even go maybe put his investments, at least after-tax brokerage account, let's say, cash accounts, potentially into a separate LLC. And the idea is that by segregating the assets from one another, we can actually try to protect those individual assets. And one of the real breakthroughs in asset protection law has been this whole evolution over the last, I guess it was 19... however long it's been since the first LLC statute occurred, but basically the key difference that a lot of people don't realize, and going back a couple of decades, pretty much everybody back then always set up corporations. And the great thing about a corporation is that if my company committed a harm, and if my creditors couldn't pierce the corporate veil, then all they could get to was the company. But where the corporation didn't help me was that if I personally committed the harm, I went and punched somebody in the nose and they sued me, or I got into a wreck and they sued me, they could come take my corporate stock. Well, so in other words, we were kind of protected from our inside liabilities, those liabilities that occurred inside the entity, but we weren't protected from the outside liabilities. So if I owned a corporation and I had an outside liability, they could take my corporate stock. The real innovation with the LLC statutes in most states, at least, is not only do we get that inside liability protection, so that if my law firm, if somebody comes and slips and falls on my property, then there's going to hopefully be insurance. But if not, they could try to take some of our equipment, but they're not going to be able to get to me personally. Well, that's just like a corporation. But then on the outside, it protects me as well. So let's say I get into a car wreck and I own an LLC. What happens is that the creditor can certainly sue me and try to get a judgment, and they can then try to take my membership interest in the LLC. But many states, including Louisiana, have a thing that's referred to as a charging order. And basically what it means is that creditor can try to seize my LLC interest. But if they're successful in doing so, they do not become a member. So they're not really a true owner. They become what's called an assignee. Why is that important? Well, as an assignee, you don't have any voting rights. Yet, you still kind of own it relative to income tax, so that, as many of you know, if you have an LLC that earns $100,000, the owners typically have to pay the taxes on that $100,000 in proportion to their ownership. So if the creditor seizes my LLC interest and my company's making a profit, they are on the hook for paying the tax bill. And again, you have to pay the taxes on the earnings even if the cash isn't actually distributed. So it acts as really a good protective vehicle for people who are on the outside that might try to, sue me because I had too many drinks and got into a wreck, that kind of thing. So we find that the establishment of that first LLC can really be beneficial. Level 4 is where we actually get into, we call them on our slide the leasing LLCs, but it's a similar kind of concept that we talked about at the beginning, where we'll try to segregate the business from the operations, from the equipment, from the cash, and by having separate entities, we can lease back to the main operating company. There's ways to pull money out so that we can kind of segregate it. We have a lot of clients that obviously are in real estate, so what we'll do is a lot of times we'll set up a parent company. That parent company in turn has multiple subsidiaries, and then in those subsidiaries we'll put each parcel of land into separate subsidiaries. That way all of it flows through to the parent company, which owns 100% of the subsidiaries. The parent, that way you're filing one tax return. All the monies can arguably, eventually kind of go up to the parent. You can pay your expenses through that, right? But then by segregating the various subsidiaries, if somebody injures themselves, there's a gas explosion on one of my doubles, they might be able to, that creditor might get the double, but they're not going to be able to get my other parcels of property. So by setting up these various, multiple structures like that, we can protect them. There's some other things here that we can do as well. We can certainly consider the creation. I have it titled on the slide as an ILIT, an irrevocable life insurance trust. But arguably, if you have a bunch of cash in there, there's ways that the ILIT could give a credit line to the business. You can actually, there's financing companies out there that if you have a bunch of accounts receivable, that they'll actually finance your accounts receivable, so that if a creditor tries to then take your accounts receivable, you've already kind of gotten the cash, or maybe put it into an insurance policy. So there's some things like that you can do as well. Level 5. So all the things we've talked about so far is kind of either, moving assets or converting an asset or structuring the asset in different entities. Well, level 5 is, what if we actually put it into a structure where we're eventually not going to own the asset, or at least the bulk of the asset. So a family limited partnership, or an FLP, or commonly now we use LLCs, so a family limited liability company, can potentially own your non-practice assets. So we've got, again, clients in real estate, for example, that will set up that parent company as a family limited partnership. And the concept is that we can put, real estate or investment accounts, pretty much most things other than your home is, typically in these kind of structures. And what winds up happening is that parent company, in the operating agreement, or if you have a corporation in the stock and the bylaws, we can create a very small number, like let's say 1%, Class A voting shares, and then a much larger block of Class B non-voting shares. And the concept is that we can transfer those non-voting shares to a trust, and now it's out of the client's name. Similar to the client I mentioned to you earlier that had that suit out of state, that's kind of the structure we use. Well, if you think about it, in general terms, assuming that you can get around any kind of fraudulent conveyance or revocatory action, a creditor can't seize what you don't own, right? So if we actually start now looking at these structures, what the FLLC allows you to do is to actually continue to own the company within the family unit. You can still control it because you have the voting rights, but you've transferred 99% of the company typically to a trust for the benefit of your kids, and you no longer own it. So you're controlling it, but you only have 1% of it. So this is another structure we can look at for clients to try to protect their assets. There's some other stuff, it's equity stripping concept. I kind of alluded to this earlier, where if you got a client that has a home and there's no debt on it, then arguably you can go put, a mortgage on it, take the cash out, and then move the cash either into an insurance policy, into a FLLC, into a trust for the kids. Again, as long as we can, we're not running afoul of the fraudulent conveyance statutes, we can do that. You can sell the assets to an intentionally defective grantor trust, or establish a qualified personal residence trust. Those are some tax structures, trust structures that us tax attorneys use to not only do asset protection, but to also generate some estate and gift tax savings. Level 6 protection, domestic asset protection trust. Again, I'm going to briefly go through that today, but we're going to need to do a separate thing on the DAPS. I didn't realize I'd been speaking that long. Apologize. So let's just go through this one today, and then we'll do another one, I guess, on the Delaware Trust that we have specific on it. But basically, the concept is that in the last, I'd say, 8 to 10 years, several states who were seeking, to encourage investments in their states have gotten these statutes now whereby the trust statutes have varying degrees of protection for a client. So understand that even though we could set up a Delaware trust, let's say, you don't have to be a Delaware resident. You can be a Louisiana resident and set up a Delaware LLC or a Delaware trust. Now, in order to do that, the entity, so in this case the trust, has to have what's called a nexus. They have to have some relationship with their state. One of the interesting things, and one of the common ways that this is done, is through the appointment of a Delaware trustee. Through our affiliation with a group, we actually have the ability, we have a Delaware trust company that will serve in that capacity. I think they're about $3,000 to $5,000 a year, regardless of what the assets are we put into it. And most people, if you know anything about this, would say, well, how in the world can they do it that cheaply? A lot of the trust companies, do it for like 1% if they're the trustee. The answer is that the Delaware statute unbundles the fiduciary responsibilities of a trustee. So what do I mean by that? Well, if you have a Louisiana trust, that trustee is a fiduciary, and for all purposes, that trustee is responsible for making sure that the investments are managed properly, that trustee's responsible for making sure that he's balancing the rights of the income beneficiaries with the principal beneficiaries. That trustee is responsible for deciding who gets distributed assets and who doesn't, on and on. Under Delaware, it's interesting because by state statute, they actually break down and statutorily, they actually have statutory provisions so that you can have an administrative trustee, which is what I just referred to, where all they're doing is really just kind of back house, back of office kind of almost paperwork, serving that capacity, but they don't have really any other responsibilities. And by that statute, we can put into a Delaware trust, for example, we can name a distribution trustee, and it might be your brother or your friend. And that person is responsible for determining when distributions are made. You can appoint a trust investment advisor, and that person might be a financial planner that's going to decide how the assets are invested. You can even appoint what's called a trust protector, and the trust protector can be given very narrow or very broad rights relative to that trust, including the right to change the beneficiaries, believe it or not, under state statute. Now, I just saw a face in our audience, and that's the common reaction is, why in the world would a client want the ability to change a beneficiary of a trust? Well, why would they? Well, let's start with the fact that most of the trusts that estate planners set up are irrevocable. That means that they're not supposed to be able to be changed. So you've got a client, he's 50 years old, he's very successful, he got married later in life, he's got a 15-year-old, a 17-year-old, and a 23-year-old, and that 17-year-old's a problem. But it's my daughter and I love her, so I want to take care of her, so I'm going to set up this irrevocable trust. I'm going to treat all three of my kids equally. 5 years, 10 years, 15 years go by, and that child's become a problem. Not talking to dad, not listening to dad and mom, not communicating with them, on and on. Well, that trust, if it's under Louisiana law, we can't just go willy-nilly change a beneficiary, but under Delaware law, we can. So a lot of times the client will appoint their attorney as the trust protector, and you can put a provision in there, for example, so that the attorney's limited, that one of the things that the trust protector has is the ability to change the beneficiaries, but only to people that are in a class of people that are direct descendants of the clients. That way the attorney can't go appoint one of his friends to be the beneficiary kind of thing. So there's some really neat things that we can do. Delaware law doesn't have a rule against perpetuities. There's a lot of, and I'm kind of focusing in on Delaware, but other states have similar but not the same types of issues. So there's some people that believe that the Nevada, DAPT, the Domestic Asset Protection Trust statute, is best. Some people believe Alaska's better. Again, for me, it's always about, let's figure out what the client is looking for, what's their objectives, and then let's match the right trust state, if you will, to their objectives, because there are some fairly significant differences between the states. But we have the ability as a Louisiana firm to actually draft the trust and for a Louisiana client, and then they can sign it as long as we have that administrative trustee in effect be, serving so that we can establish a nexus. And that includes self-settled states. So in other words, most of these states that we're talking about with these DAPs, in other words, it's one thing, there's a pretty clear distinction in the law generally that in almost every state, if the funding of the trust came from a third party, i.e. my parents left money into a trust for my benefit, if it's a spendthrift trust, those assets are almost always protected from creditors, okay, from my creditors. There are some exceptions, but again, almost always. What about if the client puts assets into this trust? In other words, it's self-settled. Well, that's where these DAPs come in. It is a self-settled trust. And before this whole DAP, concept kind of came to the forefront in these states, the general rule was in Louisiana, if I put my assets into a self-settled trust, arguably my creditors can get to it. Otherwise, people would just be dumping stuff into my own trust and avoiding it. Well, some of these states actually have said, even with a self-settled trust, your assets are protected from your creditors. And one of the ways they do that is when you transfer it, typically you are a permissive beneficiary. So we can have a client that transfers assets into a Delaware DAPT, and that client and their children and their grandchildren are possible beneficiaries of the trust. The distribution trustee alone can decide who they're going to distribute to, and they can distribute everything to the kids, everything to the grandkids, or everything back to the client. But because they have that kind of discretion, it's not really reachable under these states' laws. And generally speaking, again, there's always going to be some exceptions from that client's creditors. So typically these are self-settled trust. Client in Louisiana establishes a Nevada DAPT, transfers his assets into there. He's a potential beneficiary along with his family. He appoints a friendly distribution trustee who can then make these kind of decisions. And it's kind of oversimplifying it, but that's basically how that works. And then lastly, is we can certainly always look at offshore trusts. You always need to proceed with caution. Again, there's several countries that have laws that just basically say that we're not going to respect the judgment of a foreign country. And if that's the case, then by putting these assets into these offshore jurisdictions, arguably if there's a lawsuit that emanates from the United States and you try to then try to attack that trust that's set up offshore, they're going to have to now get a lawyer down in that jurisdiction. Again, it's another roadblock. Is it foolproof? Once again, nothing's ever 100%, but it's now an additional barrier that they have to go through. Again, the costs go up because now you're talking about going out of the country. You need a nexus down there, all those sorts of things. And there's some risks there too, right? Because if you're going to set up in a jurisdiction that's not in the United States, then you better make sure you're setting up with a government that's solid, stable. You don't want to be getting into some situation where politically, like they did back in the day with Cuba, where the government just went and took private property. So you want to be careful with that kind of stuff. So I hope that everybody has gotten a good deal of value from today's presentation. We will be doing a separate one. I'm sorry, us attorneys can be long-winded sometimes, and this one a little bit longer than I anticipated. But we will be doing a separate one on the Delaware Asset Protection Trust. If you ever have any questions about estate or business planning, please feel free to visit us at our website, which is www.lawealthplan.com. So LAWEALTHPLAN.com. Again, I'm Todd Villarubia, and if we can ever be of value to you, please contact us. Thank you.